the possibility that you would still be entitled to further severance, which would be a separate thing from bullying and retaliation. So you couldn't raise the same issues that you've raised in the WorkSafe BC complaint again in a civil claim. But you maybe should speak to a lawyer if you aren't sure if your severance package that you received upon the termination was appropriate, as there may be something that can be done on that end, assuming that WorkSafe BC did not provide for any severance payments or anything along those lines. It would depend partly on what the adjudicator decided. Um, and what was awarded to you or what the result of that complaint was. So it may be a good idea to have somebody review not only the WorkSafe complaint, but also your severance entitlements. Um, JC from YouTube has asked, when an employer fails to accommodate a disability that has resulted from an injury, how is the human rights portion of severance calculated? There actually isn't a human rights portion of severance. Severance is a separate entitlement. So when you're terminated, you receive termination pay, so notice of termination or pay in lieu of notice. And in some cases, like in Ontario in particular, you would receive additional severance under the ESA. Overall, termination pay is sort of usually referred to colloquially as severance, but in Canada or in Ontario and BC, it's actually calculated as two separate things um, under the Employment Standards Act, at least. Um, Under the common law, severance is fine, but it encompasses the same amounts. Um, that being said, it's possible that you could receive human rights damages, which would be general damages, not severance pay, um, in the event that you were successful with a failure to accommodate complaint um, or application brought through the Human Rights Tribunal, um, depending on whether or not you've been terminated as a result of the injury, um, whether or not you've been terminated as a result of the injury um, would also impact how it is that you would approach potentially receiving more receiving the human rights damages in the first place. So if you were to file a lawsuit through the civil system, it's possible that you would be able to recover some human rights damages as well, even if you didn't go through the tribunal. Um, your employer has to accommodate you up to the point of undue hardship. So that's a pretty high threshold. For most companies, it's almost impossible for them to prove that the accommodation will not is totally impossible up to that point or meets that threshold. So if you're concerned that your employer has failed to accommodate you um, as a result of an injury or disability of some kind, um, it certainly would be a good idea to contact our office and have somebody review the circumstances of your particular case. Um, so Videoland from YouTube has asked, um, union member from Ontario has asked, is my union my legal rep to file a human rights complaint with the OHRC, so Ontario Human Rights Tribunal, or can I seek my own legal counsel? It's about a religious exemption to the vaccine. Um, Generally, you should go through your union and file a grievance to deal with sort of any issues arising in the workplace. That's generally your first step. Um, with respect to the Ontario Human Rights Tribunal, you can generally file without legal counsel at all. So they shouldn't be your only avenue, but that would also depend on sort of what the terms of your collective agreement entail and what it is that they require you to do procedurally with respect to your union rep and addressing concerns in the workplace. Um, I will say that you mentioned that it's about a religious exemption to the vaccine. Um, the Human Rights Tribunal does have a policy mandate posted that you may want to take a look at. Um, there's a paragraph towards the end of their vaccination policy that may be helpful in terms of informing sort of whether you think it's going to be worthwhile to move forward with your complaint. Okay, so George from YouTube has a long question. It says, my employment contract does not specifically state a location where work is to be performed. I was hired 4 months before COVID and then working in the company's office during that time. When COVID hit, we switched to working from home and have been doing so for the past 2.5 years. We never signed a new contract stating that we'd be working from home from then on. My employer recently announced it would be implementing a new hybrid work model where we would have to work in the office 1 day a week and from home 4 days a week. At the same time, it introduced a mandatory vaccination policy saying employees need to be vaxxed to access the workplace. Do you believe there's a reason why the vaccine policy doesn't clearly state the employees need to be vaxxed as a condition of continuing their employment? What would that reason be? Um, okay, so there's a lot of parts to your question, George. I'm not sure that this is the best avenue for me to answer. I don't have any beliefs one way or the other that I care to express. So I can't explain to you why it is that the vaccine policy would be written the way that it was. Um, it's up to the company to write their own policies, and their counsel probably contributed to that as well. That being said, if it's not clear to you what the policy is requiring or what the conditions of employment actually are, certainly you should look into that. Um, have you spoken to the employer about accommodation, um, wherein you make the argument that you have not been required to work from the office in person for more than 2 years? All of your work has been getting done. Everything's been fine. So, for the purposes of this ongoing period while the vaccine policy remains in place, would they consider allowing you to, uh, not do the 1 day from the office that they apparently now are imposing? Um, I think if you want to sort of discuss further, it would be a good idea to call our office and set up an intake consultation where you can sort of go through the policy in more detail, and whatever lawyer is assigned to your case could take a look at the actual documentation that you're referring to. It's a pretty big question for for this forum, unfortunately. I've already filed my lawsuit against my company for discrimination. The trial date is a year from now. Would quitting my job and finding another impact my case? This is from Jay the Travel Dude. Um, I'm not sure exactly what it is that you are meaning when you say you filed your lawsuit. I assume you have counsel who would have filed it for you, unless you're talking about in the Human Rights Tribunal, in which case it's your question sort of is one way or the other. So, would quitting your job and finding another impact your case? Um, I'm presuming that this is a Human Rights Tribunal complaint. If you get another job before it is resolved, then you would impact the award for lost wages because a company is only required upon a termination or something like that. Sorry, upon a termination, a company is only required during the notice period to make up for your losses. Any earnings that you make during the mitigation period during the notice period are called mitigation earnings, which means that they are mitigating some of your losses. So they're making up for some of the losses that you've suffered. So it would impact your case in that respect. I can't speak specifically to your individual case though with I just don't have enough information. Um, but it wouldn't if it is in the Human Rights Tribunal, it wouldn't discontinue your case for you to quit your job. It just likely getting another job will have an impact on whether or not, what the actual quantum of your damages ends up being in the end, based on what you earned during that notice period or during the lost wages period before the trial. JC, just meant if it's based on years of working with the company, like up to 24 months pay, or if it's more of a flat rate structure. So this is a follow up to the question about how human rights damages are calculated. It's quite varied. It's not based on your years of service. It's not based on your age or length of service or position or any of that stuff. It's generally based on what the offense was and the seriousness and sort of the details of each particular case. Um, General damages awards can, excuse me, can range anywhere from, a couple $1,000s or a couple $100s to, I think there's a decision where around 150,000 in Ontario, I believe, kind of recently. It's generally more in the range of somewhere between 0 and 20, maybe 0 and 15 even. It's usually pursued in the context of severance as an added element of a civil claim. But in the Human Rights Tribunal, obviously, it is what you are pursuing, is getting those general damages. So Nompack from YouTube. I got laid off a long time ago due to outsourcing at a bank, and they gave a few months' notice. My manager said my end date would be September verbally, but he's been stringing me along because he needed me still due to delays. I just left because it was a toxic place and I couldn't collect EI after September. Was there something I should have done to just leave and collect EI? What should I have done when September hit? I'm sorry, Nunpak. I'm not sure that I understand the question that you're asking here. Um, and I'm also not sure if you're talking about this year, like a current thing, or if this is sort of back in time. If you have questions about EI, the best place to get those answers is from Service Canada. Um, the appeal process, all of that stuff, all goes through Service Canada. I'm not sure why you wouldn't have been able to collect EI beyond September and so on. So they would probably be the best contact for you to make if you have questions about that process. Keith Smith has asked, can you settle your case during the arbitration process in a wrongful termination case? And can I recover my attorney fees in arbitration as I was an at-will employee? Keith, I'm guessing that you might be from the United States somewhere. I'm not licensed to practice there. We don't have at-will employees in Ontario or BC. It's just not a thing that we have in Canada. So, or at least in Ontario and BC. So you can settle your case as part of any arbitration process ahead of the arbitration. Arbitrations are binding. So once the decision's made, the decision is made. And in terms of recovering attorney fees at an arbitration, I'm not sure exactly how it works in wherever you're working, but generally you can get costs of some kind throughout the litigation process or arbitration process. Okay, so George has asked about the mandatory vaccination policy again, saying that he's wondering if it could be argued that the new requirement to be vaccinated in order to access the workplace constitutes a substantial change to the terms of his employment and whether he could resign, claiming constructive dismissal. Um, you're correct that we typically advise against resigning, but you've said you would prefer to go down this path if it has a reasonable success rate instead of waiting to be put on unpaid leave or dismissed for cause. The reality is that it's a very risky thing to do. There are not any court decisions at this stage relating to ununionized employees, non-unionized employees, um, and vaccination. And what the ultimate decision of the courts are going to be is very unclear. You don't have any precedents to rely on at this stage. Um, you could certainly make the argument that that it constituted a substantial change to the terms of your employment that you didn't consent to. Um, but how the courts are going to deal with vaccination cases is a bit unclear. Um, I would certainly not advise that you resign if I think about it from your perspective. It would actually be better for you likely to wait to be put on unpaid leave or dismissed for cause, because those are legal questions that have answers. Um, the vaccination sort of evolution of that process and sort of the vaccination commentary in the law is not clear at this point. So I think you're taking a risk if you resign. What is clear is that if you don't consent to a layoff, you can't be laid off, and that causes a high threshold to meet. So if one of those two things happens, you can almost set aside the vaccination aspect of your case, or a lawyer could almost set aside the vaccination aspect of your case for the most part, and make the argument that you were either constructively terminated by way of an illegal layoff that you didn't consent to, so don't sign anything, or that it does not amount to cause for termination and prove that. So, more likely, those seem to me, at least, to be more likely to be successful approaches to getting severance at this stage, than resigning and alleging constructive without just on the basis of the policy. Um, Email question from Emily. I was let go after 2 months. I never signed an employment contract, but my employer is saying I do not get severance because it was in my probationary period. Is that true? Um, Yes, and there's a 3-month probationary period in, employment, under the ESA. So under the ESA, you would only be entitled to, um, severance after the first 90 days, and that goes for the BC one, the BC employment standards as well. Now that being said, because you didn't sign an employment contract, it is possible that um you could pursue severance. The reason being that any probation period has to be expressly discussed in an employment contract or prior to someone being hired, in order for it to be relied upon by the employer to limit their obligations. So under the ESA, no, they would not owe you severance, but at common law, it's possible that you could maybe pursue something. If you wanted to speak to somebody in our office about it, your entitlements probably wouldn't be very high, so it may not be worthwhile to pursue it. It really depends. But if you want to have somebody take a look at it, you can contact our office and set up a consult. Okay, well, that's all for today, everybody. It was nice talking to all of you, and I hope that was helpful. Thanks so much.